Hi, I'm Janice Switlo, and today I'm going to discuss a little bit of the aftermath that has occurred as a result of conditioning through residential school system, public school system, and how Indigenous nationals have been treated by the various Canadian governments. And it's this, the question I've received is, well, who's going to protect us? Now that is consistent with being primed to view yourselves, for Indigenous nationals to view themselves as needing the protection of others. Why? Because they've been treated as wards of the state, as children, if you will, and in need of protection. So to answer that, first and foremost, no one really. You have to protect yourselves, and you have to insist on the protections that are owed you. If you do not insist, despite the fact they should be forthcoming, they won't be, because it'll be looked upon as if you have abandoned your right to those protections. Now, why do I use that term? Because the treaties are more of a protectorate nature. They are not peace treaties where you were in a war and Indigenous nationals were about to be slaughtered, and so they waved the proverbial white flag to sue for peace, and as a result of that, a peace treaty was entered into. These are not those kinds of creatures. Instead, we have a requirement through the treaties for the Crown to engage in certain supportive measures. So, for example, and of course Her Majesty acts through her federal government in terms of providing and engaging in the diplomacy that's necessary for fulfilling these duties. Let's look at what the federal government is encouraging, and that is incorporation and turning a blind eye to the conversion of assets, and I've done a whole episode on that before, the conversion of collective assets into the holdings of private companies. It's a classic. Lawyers are at fault here too, because they'll obtain instructions from chief and counsel. They will put the chief, for example, as the sole shareholder and director, or they may put chief and counsel. But in any event, and then they'll move, for instance, the feds to encourage a full surrender of reserves through the First Nation Land Management Act, have told chief and counsel, well, if you do this, we're going to give you all the money we hold in trust. So now that money is then given, and this is what's happening with claims too, and I'll talk about that in a separate episode, that this money is coming over with no checks and balances, no protections. And once these assets are in a corporate setting, that now becomes the private holdings of that corporation. People will call, it's a band company. Well, no, it's not, unless every single band member has a full shareholder. It's not really a band company. It's a private company where certain individual band members control it and own it. Now, what happens when the monies are held and protected by the Crown, and I appreciate they haven't always done the best job, but theoretically, as it's supposed to be, they're protected and governed under the fiduciary duty of the standard of duty. What that means is that the funds must be protected in a trust-like manner. They must earn not just a low return, but really best use, best return possible. And in all sorts of particulars, and I don't intend to cover fiduciary law, but it's the highest standard, if you will. Now, a company only has a duty of care, and the business model, the management decision standard is extremely low. And first and foremost, the vast majority of band members don't have direct access because they're not shareholders. Even if they did have direct access as minority shareholders, for example, they would have to come up with thousands of dollars, if not more, in order to hire a lawyer to run any allegation of breach of duty. But because the standard is so low in terms of the duty of care, the management standard of business, it's very unlikely to succeed, even if you do have the money and you do have a good lawyer to pursue. as opposed to the much easier case to bring an action in breach of fiduciary duty. But regardless, if the money's gone, you know, you look at Frog Lake, I think it was 162 million in 2 years just brought in on the basis of what Band Council resolution, and no one knows where it's gone. Well, a couple people at least, or at least one person must know where that's gone, because someone wrote the BCRs that triggered the release of money from Canada. So what most people are not realizing, most band members are not realizing, when they're being asked to vote on a land code, which is usually presented in something of a different name, something like a community planning or land use agreement, something of that nature. They're led to believe it's something they're doing under their own laws. They're not. It's actually a land code that will trigger application of the First Nation Land Management Act. When that happens, as said, this is a fairly recent change of policy, and it explains why so many chiefs and council have been moving forward on this, because they would like to get their hands on the money. You know, some may well for you know, good reasons, but you know, unchecked power, right, is a dangerous thing. And so when those funds are being offered and dangled, and they're coming under, there's really not much band members can do about it. And so who's going to protect you at that point? It's pretty much impossible. Once those monies are gone, tracing them, finding out where they went, all that all takes a lot of money. And it also takes, you know, the ability and stamina and energy to deal with all that. It's far better to have a structured situation where if money is to be transferred and brought into control under your governance, it needs to be done in a certain way, in a safe way, in the way that countries do it, because that's what you are. That's all I have to say.